CRJ 230, this is your podcast for week number 14. We've covered a lot of ground to this point in time. If you take a moment and you look back where we started through last week in the Brady Doctrine, looking at documentary or data evidence, the whole breadth of where document and data evidence have gone and all of that, you, and I have covered a lot of ground, a lot of material, a lot of things that are relevant to your success in any area of law and justice. And I hope as we face the final 2 weeks after this week of the semester that you feel the same as I do, that you've acquired a lot of knowledge and, I would suggest, skill sets relevant to being able to find the law, read the law, apply the law to whatever your circumstance may be in law and justice, to help you do your job, your part of the mission, whatever that part of the mission is. And, sincerely, I hope that that's where you are. There's an assessment for this week, and I sort of roll that out in all classes when I'm able or when time allows. And that gives you an idea to reflect on these things, and me an idea of, if I'm doing a decent enough job. I'm not talking about the college's course survey that you may have received a link to. I'm talking about something that's specific to me, to you, and to the content of this course and the other courses that I may have you in. So please pay attention to that. That's in a separate forum. And it's not graded. It's an assessment. It gives me feedback. It gives you an opportunity to think about things. So please give it the time to think about things and be honest and open and hopefully reflect, on the journey that you've completed in 14 weeks, that you put in the work to acquire knowledge that you didn't have. And this is higher level knowledge. I don't water down expectations for you from, say, what, if you haven't obtained a bachelor's degree yet, what you see in a course in your junior, senior level of college, and to a degree, not even what you'd expect in law school. In fact, I kind of tend to think that what we do here is a little better than that, in the sense that we focus on what you need. We're not doing a lot of theory and a lot of, pontificating on the law and then, philosophizing. We are more focused on what do you need to be successful, to serve other people within the law, in law and justice careers. All right, so that's enough of that. So this week, we're really winding back to what many of you probably thought of as being evidence prior to this course. The smoking gun, the real evidence, the physical evidence. And now we know that, all those things are important, and they very much help to prove or disprove an issue in a case. But we know that they're not always present in the level or at the level as we might think of from, television dramas or even real life stories of a circumstance, a crime, as presented in a television show or whatever, a podcast, TikTok video, whatever yet. Those are summaries. And they gloss over a lot of things. As we know now, most cases are proved by a whole lot of circumstantial evidence that may incorporate physical or real evidence and brought together. So as we go through week 14, we circle back to real evidence and physical evidence, something that we introduced and talked about and its role in the early weeks. To review, real evidence is evidence that is addressed directly to the senses, such as by your sight, your hearing, your touch, your taste. It's tangible, if you remember tangible and intangible. Last week we covered the Brady Doctrine, which talked about a lot of the things that were, when Brady came down, document, expanded to data of all sorts. The world we live in now, where you don't turn any documents into me in the sense of something that's printed on a piece of paper, right? And how all that relates. Documents are often intangible. In and of themselves, they represent something else. The most likely electronic pay stub that you get from the pay you earn in your job is evidence that you worked, and whatever it was that you were paid, accurate or not, it's evidence. It's an intangible representation of the dollar amount that was hopefully deposited accurately in your bank account, right? Here, we're talking about real or physical evidence, and it's tangible, so it can be touched. Physical evidence, real evidence, involves the artifacts of the scene, the items that indicate the history or circumstances of events. Items like a gun, a weapon, a piece of clothing, blood on the area of carpet, a hole in the wall. When a lawyer introduces an item of real evidence with no historical connection to the crime, that item is most likely offered for demonstrative purposes. So we do have something that's tangible presented to the jury to demonstrate, okay? For instance, a knife similar to the one that was used in the crime as opposed to the actual knife that was used in the commission of the crime. That's called demonstrative real evidence. And the circumstance there would be that you can't find the knife, but the pathologist in the autopsy, based on his or her experience and a whole lot of training, had the opinion that the victim's wounds, the deceased's wounds, were caused by a certain type of knife. And maybe, very accurately, to a precise type of knife. Some of the tests that we use to determine whether or not something is admissible, if you remember that, are unique to real evidence. Real evidence must still pass the usual hurdles of relevancy, materiality, and competency. Because of its nature, real evidence may prove to be more persuasive than the actual oral testimony that introduces it or the documentary evidence in oral testimony, but it still has to pass those tests. It still has to be relevant, material, competent. Now, some of you will be in positions one day to be the first to appear on a scene as a police officer, the scene of a crime. And you may know from other classes that you've completed or are in now that your role is most likely going to be to preserve evidence, preserve the scene, make sure that that scene is not contaminated, that nobody else enters the scene, nothing's moved, nothing's disturbed. Some of you, at some point in your career, may be the person who arrives at the scene to process the evidence. Now, as a little commercial there, often a student will come to me and say, I want to be a crime scene investigator. There are people who are civilian crime scene investigators. There are people who go into crime scene investigation at some level. Typically, they have a much deeper science than criminal justice background. State Police, for instance, has a crime lab in Morton, staffed primarily by people who have degrees in the sciences, masters and even PhDs in the sciences. What we think of in our region or in Illinois as a general rule with local departments and even the state police for the basis of initial processing the scene are often people who worked in law enforcement at various levels, most times going through investigation positions of various sorts and reaching a certain level of maturity and age in that service where they then bid on becoming the person who is the crime scene officer. I've had several of my friends, several of my former students go through and do these things. Smaller departments typically aren't going to have somebody to do this sort of thing. They don't have the manpower, they don't have the bandwidth, they don't have the resources. Larger departments like Tazewell County Sheriff's Department, Peoria County Sheriff's Department, and City of Peoria, Pekin, will have officers who are specially trained to do these things. So just so you know that, because sometimes, especially when you're in your early stages of your education, you think, well, I'm going to go out and do this, after I get my bachelor's degree or whatever. And we can talk about that anytime, but I always like to clarify at this point that those are the realities. Those people that I just described, later by their education and training, they analyze that evidence and they process that evidence. They oversee the securing, the gathering, the processing and presenting the evidence for court purposes, again with additional training, with additional certifications, credentials, and experience. They're experts. And then some of you will work in the process of supporting the legal system in one way or another, where your role is to make sure that evidence is secure, presented, available for court purposes. Regardless of what role you find yourself in within that spectrum, what you do and how you approach your job could very well help hinder an investigation or support that ultimate court case and conviction. And as you'll see in the various cases presented and discussed this week, it's exactly how it plays out. As you'll see in the various cases, chain of custody, the ability to authenticate evidence, the issues that we'll see in the cases from adjudication, hearing, or trial, criminal or civil, these all come up. It all comes back to usually chain of custody and the ability to authenticate. Chain of custody, goes back to that officer first on the scene, making sure that the scene is secure. Nobody's touched the scene since that officer arrived. And then that the other people who are going to be involved are able to gather, secure, document, account for, where that piece of evidence was at every step of the way from that point forward until it's presented by a witness on the witness stand in the trial. Chain of custody. And authenticate, if you have your chain of custody, it shouldn't be difficult to authenticate. Authenticating it, if you remember, is essentially proving that it is what it is offered to be. It is the weapon that was used. It is the knife that was used. It is a knife that, based on the pathologist's experience and findings and testimony, was very similar to the knife that was used, authenticated. If you're entering the law enforcement or criminal justice fields, it's going to be imperative that you keep a consistent process for collection of evidence, to store the evidence, to transport the evidence to the courthouse, and then for keeping evidence safe and secure during the trial. Now, once it's passed off to the courts, typically that's handled by the courts. And in Illinois, usually with the help of the sheriff and in conjunction with the circuit clerk's office, because once it's admitted to the evidence as evidence, it's the circuit clerk's responsibility to make sure it's secure. Most courthouses have a secure evidence area. And then after the trial, until the appeals are exhausted, that physical or real evidence stays typically at the courthouse in that evidence, that secured evidence vault. It may be there for decades. It's very important, and you'll see in the cases, that it is accounted for, always. Being prepared to authenticate that chain of custody of evidence in all reports, documentation, and then being able to narrate that, being able to speak it, being able to testify orally in front of a jury, under oath. It's key to a solid case. It's key to finding justice. In criminal cases, this is most frequently, the most frequent and important issue regarding evidence you will encounter day after day. So you have to know the law. You have to know the procedures. You have to know what procedures were developed in your office or agency to meet the expectations of the law, and then you need to carry out those procedures, whatever your respective duties are regarding that evidence in this case. And if you do that, you're never going to end up in some of the cases that you'll read and talk about this week. You won't end up in those situations. Okay? Or if you do, it may be on an issue that is raised by typically the defendant challenging what occurred to them, and the court will find that you did things appropriately. I could talk about this topic for days because, as I said, it's imperative, it's connected, it's relevant, and in my career and in my even studies, my final year at Bradley, while I was working with what's now Campus Police, was then the Department of Public Safety at ICC. I also had an internship with the Peoria County State's Attorney's Office on behalf of the Peoria County Board. And what I was supposed to be doing was auditing criminal cases over a 10-year period to determine whether or not fines or court costs were being paid by people who committed crimes. And that's a whole other discussion, if you go back to some of the things that we've finally addressed and have recognized, at least in our system in the last couple of years, logically, people who were convicted of crimes and sent to jail or prison and then got out had difficulty finding jobs and didn't have an income to pay fines or costs by a certain period of time. And what would happen is that then they would be held in contempt if the prosecutor pursued it or the court reviewed it. A lot of times held in contempt and just get more fines or sent back to jail, which was a counterproductive waste of time. There were hundreds of thousands of dollars that were owed. In any event, as luck would have it, or not, at the time that I was doing this job, the then circuit clerk of Peoria County was indicted. It was based on embezzlement of funds, of converting funds of public funds of the office. Back then, most things were paid in cash or check. Paper trails weren't as easily followed or could be manipulated. And along the way, it was determined that the person who was in charge of the evidence vault was a convicted felon. At some point in his early adult life, he was in his 50s by then, and a friend of the circuit clerk, at some point in his life, he had murdered, was robbing a house, a farm, I believe, in southern Illinois, and he murdered the homeowner with a shotgun. Went to prison for 25 or so years and got out and somehow found his way to Illinois, to Peoria, I should say. He was always in Illinois. Found his way to Peoria and a job in the circuit clerk's office where he was in charge of all the evidence in the evidence vault for the circuit clerk's office. So all the evidence that was ever introduced in court, admitted by the court on a particular case, or after the case had finished at the trial level, was waiting to be dealt with after appeals had been exhausted. A felon can't be around drugs and guns, weapons. There were lots of that in the evidence vault. So, recently, graduated and turned 21 and working for ICC Public Safety Officer Tom was tapped as the person who could be trusted to go and now perform an audit of the vault and the evidence in the basement at the circuit clerk's office. And I was in the process of doing that. Thankfully, as the indictment of the circuit clerk moved forward, the Illinois Attorney General's office wanted to move into that area, and so then people from Department of Criminal Investigations of the state police took that over, thankfully. But there was a whole bunch of stuff in there. Lots of evidence from years and years ago. And it was eye-opening, to say the least. I had a front row seat to see how evidence worked. And I was very lucky, I should say that, in this part of what I'm offering you. I was extremely lucky. And I tell you this, if you can, if you go to the courthouse and observe trials, and you take the time to do that, and you let those people who work there know what your role is, that you're a student and you're seeking to enter those careers, you'll meet a whole bunch of people who will help you in your career. And I was very lucky that the then state's attorney, John Barra, who later became a judge, and I still see around every once in a while, he's long retired now, or Judge Calvin Stone, who was the chief judge, and he's way retired and still alive. People like that took me under their wing. They made sure that I was able to see a lot of things, and they were there to answer questions and support me. In any event, I just wanted to give you that little story. Everything I'm talking about, that was part of my first-hand experience with it. Now, I've had lots of other experiences with real physical evidence in both criminal and civil cases. I've told you about some of my cases on the criminal side. I've told you less in this class about my cases on the civil side. People who had me for civil litigation have heard a lot of those examples. The important thing, though, really is know the law, know the procedures. Civil or criminal, law firm, prosecutor's office, police department, probation, wherever you end up. If you're working at the jail, there are procedures to tell you what to do, and there will be crimes committed at the jail, and you will have to gather physical and real evidence. All of these things apply in any setting. Know the law, know the procedures, know what's expected of you. Communicate with your supervisors. Write good reports. Review your reports before you submit them. And then be able to stand on those reports if you're ever called to testify. And if you do those things, you're not going to end up on the losing end of one of these cases in the sense that the case falls apart and you're to blame. In fact, what will happen is if you do those things and everybody else who's involved in the case does those things, justice will be found. Whether that's justice in a criminal case of being a conviction or not, or it's a not guilty or a guilty in a civil case. So keep those things in mind. Week 15, we're going to move on and take a look at more cell device computers and wrap up with that. And then you have a final assignment in week 16. For this course, it's really not that difficult, the final assignment, if you put in the time, if you pay attention to the deadlines, because it's the final week and final exam schedules interrupt, it's a shortened week as far as the schedule is not the same, so pay attention to that. I hope all this made sense, and I hope it helps bring together the things that we need to bring together this week. I appreciate all your effort in the first 14 weeks. I hope you keep your energy up for the final few weeks of the semester to earn the best grade possible. And if you need me, you know where to find me.